Now, answering your questions about the law and legal issues. This is Legal Break with attorney Gary Bruce.
Hello there and welcome. Gary, thanks so much for being here today.
It's always good to be here.
It is. We've got some great questions today too. The first one is something that's in the news. So if someone refuses a breathalyzer in a DUI case, can that be used against them in a court of law?
And this is a really interesting thing that's just come into the news. It shouldn't be news because we have the right against self-incrimination. So, you know, you have the right to remain silent. Anything you can say anything you say can and will be used against you, you know. So why is it news that not taking a breathalyzer would be a violation of that? But that's what the Georgia courts have said now is finally you can't use that in a proof of you being impaired driving. All right, so I won't take the breathalyzer. That is not proof that I was impaired. Now, it does impact your ability to drive because you have implied consent rules in Georgia and Alabama that say if you're going to be on the roads, you agree as a condition of using our roads to a breathalyzer. And if you don't do it, then you can have your license revoked administratively, up to 90 days in Alabama, up to a year in Georgia. Wow. So it doesn't impact your license. I mean, it's still going to have an impact on that. There's some rules that you have to do that, but it does not prove you are impaired. Does that keep the proof of their being impaired from being made? No, it does not. So there's ways that you can get blood tests, you can get other samples done, but it also just the way you act, you know, it can be damning evidence really for a criminal case. And in a civil case where we see it, it's not determinative. I mean, the evidence of the situation, the witnesses, what they saw, how the person acted, that's all evidence of impairment. Because, you know, a breathalyzer doesn't really test for drugs and other things that may impair you. So anyway, it doesn't really determine much. But it can't be used to say you were guilty.
That you were, right. Interesting. So we have a man on the street question today. Let's roll that one.
Hey Gary, is it legal for a credit collection company to call me several times a day during work hours?
All right, good question. And yes and no. I guess they can until you tell them no. So you have the right under the Fair Debt Collection Practices Act to send a cease and desist letter. Look, here's the thing I tell people all the time. It doesn't matter what you tell them on the phone. It's about what you do in writing. Document it, send it, and they ought to shut them up. They can't call after 9 or before 8. Anyway, call me if you have questions.
Very good. Thank you.